Hi, everyone. How's it going? Good. My name's Veronica Reynolds. I'm an associate at Baker Hostetler. I just graduated UCLA Law this past year. I'm really excited to be here. I think that the Blockchain Acceleration Foundation and UCSB Blockchain Group has done a fantastic job putting this together, and we really thank you guys for being here. I just want to go through and let everyone give a little introduction on who they are and what their background is, maybe 1 or 2 minutes.
Sure. My name is Emilio Cazares. I'm an associate at a law firm called Shepherd Mullen. I primarily practice in intellectual property law, advising companies on their blockchain patent portfolios, as well as their trademark portfolios. Besides that, just because of my, I guess, historic enthusiasm for blockchain and its possible applications in society, as well as in corporate governance and corporate agency, I've been counseling mostly partners within my firm on the applications of blockchain tech and blockchain operations to legal frameworks and paradigms that unfortunately have not changed in light of the new tech. So you're seeing a lot of people who have been in the practice for a very long time, kind of not really understanding how to apply old case law to this digital world. So I've gotten a good chance to counsel on stablecoin issuances, as well as blockchain consortia agreements, and some data analytics for on-chain providers. Yeah.
Thank you.
Hi, my name is Morvareed Salehpour. I am a lawyer who was trained at a big law firm working with Fortune 100 companies and on the Madoff Ponzi scheme. And I now have my own practice, and I work with businesses and help them with their business and tech transactions and litigation on disputes that arise. My practice also has a specialty in emerging tech, so we work with businesses in the tech space like blockchain and AI.
Excuse me. First of all, thank you everybody for being here. I know that we're competing against the future of decentralization, which is, if I weren't here, I'd probably be there. But we're going to make sure that you get your money's worth, because the collective billing rate of these 4 right here is literally obscene. So we're going to have you walk out of here with a bunch of valuable advice and counsel. My name is Mark Hirade. I'm a partner at Mitchell Silverberg and Knupp. I'm a securities lawyer. I started out as a lawyer for the SEC, where I spent 8 years doing corporate finance and representing the SEC in their enforcement actions. In the area of crypto, I counsel clients on how to comply with the securities laws in connection with capital raising transactions, ICOs, STOs, and then advise them about liabilities, both governmental and civil liability.
Okay, great. Thank you guys so much for the introduction. I know this is the law, and I think when people start talking about the law, so often our eyes glaze over, but really the law touches every aspect of business development, innovation of technology, and so I think there's a real opportunity to look at it through those eyes, so hopefully we can dig in a little bit on the various backgrounds that you guys each bring to the table. I'm very excited to I have some questions. I'm not an attorney yet. I have yet to be, I passed a bar exam thankfully, but I have yet to be sworn in, but even as someone who has spent the past couple years really digging into this space, I still have so many questions. So first, I just want to look to the audience really quickly just to get a gauge of where we're at. Raise your hand if you know generally what a smart contract is. And if you don't, it's totally fine. Okay, great, everyone. So does everyone know what a security is, or what the Securities Exchange Commission is, or the FTC, the CFTC, sort of? Okay, a little less, that's great. And does everyone at this point know what an initial coin offering is? An ICO? Okay, cool. So I just wanted to take a quick moment to distinguish between, just very brief, we have a lot to talk about, but I always like to set the stage. I feel like there's a lot of conflation between blockchain and cryptocurrencies. So does one of you just want to quickly explain the difference?
I mean, I think one difference is that the blockchain is the technology itself, and it has a wide variety of use cases for this. It's basically a decentralized ledger system. Cryptocurrency is the one use case, and where it really took off, right? Bitcoin is the first kind of big cryptocurrency that took off, and that's how blockchain technology started to get popular in more of the mainstream.
Okay, great. I always like to set that tone because I think that with cryptocurrencies, you hear a lot of the word Ponzi scheme, fraud, and I think a lot of people still don't know all the other implications that blockchain has. So just on that note, one more kind of broad overview question. As lawyers, we get to work with a lot of different projects on with blockchain or cryptocurrencies. What are you seeing that are what promise do you see with this technology from your perspective on the legal side, and what challenges do you see kind of, whether it's regulatory or something else, kind of slowing things down?
So I can say that a big trend that I'm seeing right now is the interest that companies are having in issuing out stable coins or commodities-backed coins. So like, there's a big question around, like the securities implications of initial coin offerings. At this point, I think, the cat is out of the bag, that a lot of people are like, you have to register with the SEC if you're going to be doing these ICOs. But so people are very interested in a new financial vehicle known as stablecoins. Who's familiar with stablecoins? Are you all familiar? Yeah. So essentially, you have a price. A token that is fixed at a certain price, but the way that they fix the token at the price is they have to back up that token by an insured pool of funds that can guarantee that any token holder is going to be able to redeem that token for its face the value at any given point. But in order to do that, you can't just say that it's going to be backed up. You have to create a mechanism that involves contracts, that involves interactions between several parties, and actually securing the funds in an actual location, and creating an audit mechanism to ensure that those funds aren't ever going to be released in an improper way. But doing that, there's a lot of off-chain interactions that are required in order to facilitate it. But if it's off-chain, then how do we ensure that it's being done in a transparent way? The coins are all going to be available for inspection, but the way that those coins are backed up with a commodity or a dollar amount, that is being done to a large extent by off-chain activities through contracts. And I think that where the regulations are not catching up is kind of in defining these financial products, but what you're seeing is a lot of innovation from attorneys and privately contracting a way to create these new and innovative financial products.
Do either of you guys have anything else to add, or what's kind of driving the space forward or keeping it back?
I think it's a couple things. One, I think in the kind of short term, what we're going to continue to see growth in is more enterprise applications, because that's easier sell. It's not necessarily a true public blockchain, right? They're often centralized, but that's something that the business can set up and find efficiencies in. Longer term, it's going to be more just digitization of everything, and to get there is going to take some action from our legislatures to be able to get more movement in that space, because right now, in order to do something really innovative, there is a high cost to legal and compliance and all that, and a lot of risk. Unfortunately, our government is kind of focused on other things right now, so we're falling kind of behind in respect to other countries where they don't have those issues, and we're not reacting appropriately to a lot of occurrences in terms of innovation. For example, when Facebook decided to announce Libra, our congressmen decided to react with, we need to stop this from happening, versus how we do need to digitize. Like, how do we do that in a way where the tech isn't self-regulated, and so that we have a way to control it and make sure everything's being done in a proper way. So that was our reaction. Not great. China's reaction also, not the it's kind of scary, but they actually went to the route of announcing a central bank currency right away. And I think that's down in the next 10, 15 years, the real kind of tension is going to be between these large corporate nation states and what are traditional nation states, because now tech companies are being able to print business, which is historically something a government has been able to do.
Yeah, no doubt one of the things that's holding it back is that is innovation in the U.S. as opposed to the rest of the world are the enforcement actions by the SEC. And we're going to talk about those enforcement actions and what we can learn from them. But fortunately, the SEC is mindful that they don't want to chase off all of the innovation out of the country. But at the same time, they're tasked with administering the securities laws and protecting investors. And so they're trying to strike that balance. And we'll talk about what we see in terms of advances and hopefully some liberalization by the SEC going forward.
So on that note, actually, I think it would be really great to talk about a use case. I want to talk about the Telegram offering that was made I think it was a little over a year ago. So Telegram raised about $1.7 billion for its token network and its messaging platform. And they were about to launch the Gram token, give it to the purchasers when the SEC issued a temporary restraining order preventing them from doing that. I believe that there were actually only 171 purchasers. So I think there's actually a lot to unpack in just that little bit of information I put out there. I think maybe the first question is, the SEC stated that they stopped this issuance because Telegram didn't provide enough information and background to investors. Can you explain that to everyone? I think, why is that a reason not to issue the tokens? What else is behind that decision?
Sure, I can take that. So I think it might help if we step back just for a second, because the securities laws seem complicated, but they're really not. And keep in mind that various of our laws apply to cryptocurrencies and blockchain projects, but a big one is the securities laws, because the securities laws governs really anytime you take what I call OPM, other people's money. And back when Congress first started regulating taking people's money for investment purposes in 1933, they did so in response to the '29 crash, people jumping out of windows, the Great Depression. And so this body of regulation, which is still on the books today, is pretty strict and very draconian. So anytime you take money from people for an investment purpose, it's highly regulated. So there are really two forms of securities laws. There's one in connection with doing that, taking money from people, and basically the SEC says you have to provide to them certain level of transparency and disclosure if you're going to take their money. One of the issues is whether or not you have to register that sale of securities with the SEC. The general rule is you have to register in a process like an IPO unless there's an exemption from registration. The other body of law that applies securities laws is to the trading of securities, basically the aftermarket and the industry. Those laws relate to all of the players in the industry, the stock markets, the brokers, the transfer agents. They're all highly regulated. So that's basically the securities law in a nutshell. With Telegram, what they did was they sold, like a lot of companies do, they did a pre-sale, and they treated that sale like a security. And so they complied with one of these exemptions. It's called Regulation D. They sold to accredited investors only. About 100, a lot of them were institutions. I mean, they literally raised, it was like
1.7 billion.
Yeah, 1.7 billion. And then they had announced that on October 31, they were going to do basically what I could call a token generation event. They were going to distribute the tokens out. And the SEC at that point said, and they weren't planning to register it, at that point, Telegram was not planning to treat that distribution as a security, because I think Telegram was going to take the position that essentially what started as a security morphed into a utility token, and therefore was no longer a security. And that position, that theory actually has some basis. There's a very famous speech by the head of the SEC's Division of Corporation Finance, Bill Hinman, that he made in San Francisco, I think it was June of 2018, where he said, you can have something start out as a security, and eventually it could become so decentralized that it morphs into a non-security, and therefore the securities laws would no longer apply. And he said there very famously that that's the case with Ether and Bitcoin, that the SEC is not going to treat those as securities for that reason. So then the $64,000 question was, well, what has to happen in order for what starts out as a security to morph into a non-security? And we know what Telegram did is not the answer because the SEC said, no, what you're doing is you're still selling a security, and if we allow you to make that distribution, we're basically allowing those institutional investors who bought in the first instance to essentially act as underwriters and turn around and resell without the protection to the unsuspecting public, without the protections of the securities laws, and without having to provide them all these disclosures that we normally would require you to provide. So,
Can I put you guys on the spot really quick? So do you want to take a position on whether SEC's decision in this case, did it have value? I mean, two questions I have right off the bat. Was it a utility when they released, when they were at the point of which they were trying to release their token? And do you think that the public needed to be protected from this issuance? I mean, anyone can answer.
well, okay, so everybody probably all knows Telegram, right? And so you know the communication app, wildly popular, very functional. That was one small part of the ecosystem. It was supposedly they were going to create a token that was going to be used for currency. It was going to be used to attract developers, so that there'd be a network effect, and they'd create this great network. So no question, at least the messaging part of it worked. They really, and it's very similar to the Kik case, the company Kik that also had a messaging app a few years earlier that were selling kin tokens. They too took the position that at their token generation event, they had already created a utility functioning platform, and therefore it was a utility token. I personally think in both cases that it wasn't, in neither case was it sufficiently decentralized. In other words, it relied on the managerial efforts of Kik and Telegram, the management, to promote. Because if they didn't promote, the tokens wouldn't be worth the value that they said they would be worth. And so, in my view, they did it too prematurely.
And Kik also was, I think, a more egregious situation because they were basically going like bankrupt, failing, and then they did this as a last like Hail Mary to try to save the company. So I think that's even more clear evidence that it was, needed to comply with securities laws.
Okay, great. So I'm going to kind of move on to the next topic, talk about smart contracts. Actually, do you want to explain what a smart contract is? Is it a contract at all? I don't know.
Sure. So I think smart contracts is an area where a lot of kind of lay people and tech people get confused. They think because the term is contract, it means it's an actual contract in the legal sense of the world. What it really is a self-executing code. So it's taking certain provisions of a legal contract and converting it into the if-then provisions into a code that's executing, so you can cut out middlemen and all of that. There are complications that arise with smart contracts, and one of the initial issues is, are you actually interpreting the legal document correctly? And so it's always good to have the lawyer and the developer speaking to each other so you're making sure things are being interpreted accurately. Additionally, you have issues that arise that in terms of complications with things such as jurisdiction, enforcement, and liability issues, because you now have a transaction that is traditionally occurs on a centralized kind of system in a centralized way occurring in this decentralized system. So that's creating complications of where, if we haven't addressed choice of law appropriately, and there are even questions about how to address that, there may be various jurisdictions and different laws that may apply, and that complicates litigation that may result from any dispute that has arisen because you now have to actually spend time and money to litigate that issue first. Additionally, there's issues where tying into liability and enforcement, where you have this self-executing contract. And so you have situations where things can still go wrong, and people sometimes assume, oh, it's self-executing, it's a contract, no one's involved, so things can't go wrong. But you have situations that arise from either fraud or just still bad actors. So for an example of, and then just code error. So code error example would be the Dow hack. They didn't expect that to happen. It happened, people lost out. Now you had to somehow try to clean that situation up. Fraud, bad actor situation, I always like to use the kind of supply chain example. Say there's a tracker on some product, you're transferring it, and as it gets transferred, payments are being made out automatically. Well, in the situation, someone could, take a tracker, put it on something that is not the good that is supposed to be delivered. It reflects as being delivered, but when the person goes and inspects it, it is not actually what they were expected to get, and payment has already been paid out per the smart contract, so it's now more complicated to go and basically undo that transaction.
I think that's a really great point. And it goes to something you talked about earlier. How do we apply the laws that we have to this new technology, and how do we apply the new technology to the laws? I think what you brought up reminds me of another use case that I've talked through with some people about real estate, either transferring title on the blockchain or using blockchain as a replacement for escrow. I don't know if you want to discuss that or if anyone else has any comments, but I think it would be kind of interesting to use that as a use case.
Yeah, it's real estate is and blockchain is something that I'm, have worked in and interested in. It's complicated. I think it's an area where it's still very new, and part of the problem is to get that digitization there, we actually need a lot of the governments involved, because a lot of property records are county-based, so it's going to take a while to get those all digitized. And when you are digitizing it, there becomes the issue of the actual paper record may not reflect the record on the blockchain because there may have been an error in that process of making it digital. And then you have the situation of, well, what is given priority? Are we going to, is the presumption, and that's going to have to be established in case law or by statute, is the presumption that the blockchain record is correct? And then if we need to amend that, which would have to be with a new transaction on the ledger, we have to go to court and establish that the blockchain error is false. So those are some of the complications.
Yeah, and I was just going to say, to illustrate that point, in the financial crisis, when we had securitization of assets, receivables, for example, or mortgages, and these mortgages were bundled up in packages, they were repackaged and resold. Well, there are basic requirements to provide the underlying documentation. So years later in litigation, when the poor homeowner was foreclosed on, some bright lawyers said, well, you show me the actual transfer documents, and many cases, they couldn't find them. And so it's just an example of how digital records and keeping records on the blockchain can solve a lot of inefficiencies. The other thing I'll mention about real estate is that, it's an asset, and there's tokenization of an asset versus kind of utility tokens like we talked about in the case of Kik and Telegram, where it's tokenization of an asset, it's representing, for example, a fractional interest in real estate. We have a whole regulatory regime, and that works. Same with tokenization of securities. If a company is going to tokenize their securities, their equity, so that instead of a paper stock certificate, there's a digital record of ownership. To me, that doesn't implicate a lot of the issues that are complex. We have a whole system that regulates stock certificates, and it should apply whether it's in digital form or in paper form. Same with real estate. Where it gets complicated is, I think, where you have the token is a utility, and there's some token economics behind the business model. That is where the token is used to financially incent somebody to behave in a certain way in order to, for example, incent the creation of a network. That's where it gets interesting because, as I've said, if you're going to incent somebody financially, that's where, that's where the rub is, because the securities laws basically cover an investment, and that essentially is what you're trying to do.
Yeah, very interesting. So I know we're getting short on time, so I just wanted to point it to another topic, IP and patent prosecution. What role does blockchain play in that world?
Sure, yeah. So the big thing right now with blockchain intellectual property is subject matter eligibility. So in order to obtain a patent, you have to prove a few things to the patent office. You have to prove that it's an invention is new, which in the case of blockchain hasn't really changed that much. The patent examiner can go find some type of disclosure for blockchain that pre-existed your specific idea. But the big problem is whether or not you can get a patent on the idea in the first place. And the confusing thing with blockchain is that what makes a blockchain extremely powerful is that it, to a great degree, optimizes the way that people can exchange rights between each other. And by rights, I mean like if I have 10 at Bitcoin and I send you 10 at Bitcoin, we have exchanged a right with respect to each other. However, that type of interaction is a fundamental economic practice, right? I can hand you $10, and that's something that we've been doing since the forever, exchanging currency between each other. But Bitcoin has enabled that solution on a huge scale, where you can do that with a stranger from around the world. So what the patent office is struggling with right now is where these blockchain applications, they come in and they try to get a patent on a digital escrow. And a digital escrow, like in the case of real estate, is a conceivably very powerful idea, right? Like I can have an escrow account that's gonna hold the money, and it's gonna await authentication from an agent, it's gonna await authentication from a seller, and the money will remain in the escrow until the proper authentication criteria are met, and then the funds get transferred. It's a powerful idea that could revolutionize the real estate market on a global scale. But that idea fundamentally is an economic practice that has been practiced for a very long time. So you're seeing a lot of these blockchain applications that try to claim a broad idea as opposed to having a more specific claim directed to a technological advancement or something that makes this escrow more efficient than the other type of blockchain escrow. So this has been a body of case law that has been around since 2013. There was a big case called Alice, and it's an infamous case in software patents that's being aggressively applied in the blockchain space. Every single patent I prosecuted, I get a rejection from the patent office, no matter what the invention is. It's not eligible for patent coverage because it's directed to a fundamental economic practice or a pure economic activity. Or in the case of the types of solutions like, let's say like CryptoKitties, like creating content and distributing that content on a network. It's like that was done in the internet. It wasn't done in the same way, but it was still done. So these types of optimizations that blockchain creates are being attacked by the patent office. There is some suggestion that this is changing, however. Right now, Congress is trying to make some changes to Section 101, which is the subject matter eligibility for patents, and they're basically going to give more credence to applications that are directed to practical applications. So in the case of blockchain, if your invention is being accused of being an abstract idea, and you're able to form an argument that it's more drawn to a practical application of that abstract idea, then there's a better chance for patentability. But in any case, I think that not just on the patent side, in obtaining patents is where blockchain is going to make a big difference. I think it's more in the coordination between the patent offices around the world using blockchain technology. So trying to represent a patent application as a right that is understood on a network as belonging to particular people or even groups of people, I think is where blockchain and patents really come full circled. So there's already a bunch of cooperation between the patent offices on, like on prior searches and which applications are valid where. But I think where the big game changer is where all the patent offices start to recognize one invention as being a worldwide application that is recognized on a blockchain, and then hopefully facilitating the market's interaction with that patent application. So this kind of opens up the door for like, all right, do I want to invest in IBM as a company, or do I want to invest in IBM's patent portfolio specifically? Like, can I have a stake in a patent portfolio specifically as opposed to a company?
So, this sort of brings me back to this question that I really have a lot when I go to these events and I'm talking to people. And I'm just, we're running out of time, so I want to ask you guys, what we've talked about are different use cases for blockchain. What I'm hearing, and please correct me if you want to clarify this, but what I'm hearing is blockchain has the potential to solve a lot of these problems, especially with middlemen, as we saw with cryptocurrencies or other blockchain use cases. But does it create different problems that point back to the benefits of a sort of centralized authority? Why or why not?
Yes, I mean, I think.
And this is our last question.
A fully decentralized system doesn't work because there's no one to enforce or find liable for. And yes, that may sound good in theory. In effect, to have business, we need some kind of centralization to a degree, and that's the only way it's going to work. And that's why these enterprise applications have stronger footing right now, because you're able to clearly find if something goes wrong, who is responsible for the blockchain, things like that. Otherwise, as you get more decentralization, you have things such as node operator liability, and you get parties that shouldn't necessarily be liable being called into court because that's who we have knowledge of.
Do you have any comment on that as well, Mark?
Yeah, so I think, so just stepping back, a definition of a security in order for all these securities laws to apply is an investment of money with an expectation of a return based on the managerial efforts of others. So it's that managerial efforts of others. So if it's truly decentralized, it's really not reliant on the managerial efforts of others. It's reliant on the managerial efforts of everybody in the network. And if we don't have that decentralization, then at least when it comes to raising capital, it's going to be deemed a security under our existing securities laws. But having said that, the SEC most recently, in its most recent enforcement action against Block 1 in September, seems to be backing off. And so what we're thinking is that that's encouraging, because it looks like the SEC is recognizing that they can't keep hammering these companies. And it might have been the fact that Block 1 was more cooperative, whereas Kik and Telegram were very publicly kind of against the SEC. But I think we're going to see a little bit of easing and a little more clarity soon.
Maybe they just had better lawyers.
Maybe.
Thank you, guys. Let's give a round of applause for our panelists today, and also for Cameron, the Blockchain Acceleration Network, and UCSB. Thank you guys so much.